Good morning. You're so attentive this morning. We'll have a little coffee for you coming up. So ease your morning pain. Thank you so much for coming today. This is a first for us. It's a joint conference between the McGuire Center for Ethics and Public Responsibility and the Tower Center. And we began a conversation a number of months ago about the anniversary of 9/11 and then the anniversary of the Patriot Act, which we've just observed. So 10 years later, we are very concerned about the notion of civil liberties and national security and looking at the ethics behind that, frankly. What are our values and how do we enact those values? I think you'll agree when you look at the program. We have an absolutely amazing lineup of speakers to talk with you and to explore those issues with us today. On behalf of the McGuire Center, we thank you for being here, and we hope that you will get a chance to look at the materials from the McGuire Center and see some of the works that we are doing to try to drive the conversation of ethics throughout the community. You probably already know Jim Hollifield, my counterpart, but he wants to say a few words on behalf of the Tower Center.
Sure. Yes, well, let me reiterate what my colleague, Professor Kirk, just said, which is welcoming you all here today. Here's the man of the hour, Mr. McGuire. Find yourself a seat. I think you're in for an absolute treat in the day, and I have to give all of you extra credit for being here at 8:45 on a Saturday morning. I'm just really impressed. I'm sure there are going to be some others coming in. One of the things, this is a great room for doing an event like this. The biggest single problem is everybody wants to sit on the edge. And then when people come in, they have trouble getting inside. So when you sit down, if you could leave a few seats on the end so that people who come in late can sit down, that would probably lead to less disruption and fewer people stepping on your toes as they try to come across the rows and aisles. Next to the last thing I wanted to say is to go back to something that Rita said. Where did the idea for this come from? And I can tell you exactly where the idea came from for me. It was when the Patriot Act was passed many years ago. And one of my board members, many of you know Alan Feld, of Aiken, Gump, Strauss, Hauer, and Feld. Alan was concerned about that Patriot Act, and he said, you know, we really ought to do a program on this. And it only took us how many years to actually put this thing together. But I'm delighted that we're there, for all of you coming from out of town, for all the Tower Center aficionados, for the students in particular. I see a lot of my students here, and boy, you guys are going to get major kudos for coming down at this hour of the morning. Extra kudos. Right now, it's my pleasure to introduce to you my colleague who has made such a huge difference for the Tower Center since he came here a few years ago, and he holds the John Tower Chair in National Security and International Politics. Many of you know him. The students, of course, know him. This is a field that's perfect for him. It's a subject that's perfect for him, and he's going to be sort of the maestro, in a way, helping to guide this. He really worked to put this program together. If you all would just join me a moment in welcoming up here Professor C.M. Brown.
Thanks, Jim. We're going to get right to it, and I just want to indicate to you what the rules of discourse are. We operate according to Chatham House rules. That means that you may not, outside of this room, identify the source of some idea that you've picked up or that you've heard expressed. You may not identify it by name. Substance is fine. You can even claim in a plagiaristic way that you're the author of this idea. But you're not supposed to identify the name of who has made a comment. And this will prevail throughout the whole day. I'm going to turn the discussion over right away to my colleague Joe Kavilka, who is one of our experts in the Supreme Court, on the Supreme Court and on constitutional law, and he will introduce the panel. We are not going to go through long and flowery introductions because you have the basic biographical information inside of your program chart. Joe, it's your panel, and give us what you can.
Thank you, Sam. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. The preamble of the U.S. Constitution. It establishes a framework for popular sovereignty. It establishes a framework for a limited government. And with the addition of the Bill of Rights in 1791, it establishes specific rights guaranteed to the people. 9/11 and the resulting war on terror have put these values and principles to the test. CM asked me to be an active chair. I'm not sure exactly what that means, other than I'm not supposed to fall asleep, which isn't going to be an issue. But let me just frame this with some words from Abraham Lincoln, president in a time of American crisis. At Gettysburg, he said that the Civil War tested whether this nation or any nation so conceived and so dedicated could long endure. He also said, must a government of necessity be too strong for the liberties of its people or too weak to maintain its own existence? In a very real sense, these are our concerns today as well throughout the course of this program. Now, the panel that leads off this conference deals with basic legal and ethical controversies. Let me just give you the rules of the game. Each speaker is going to speak for about 10 minutes. Then we will have 20 minutes of conversation among the panel. And then I will open it to questions from you, our guests. As you listen, feel free to jot down notes and ideas to ask questions. And remember that a question ends with a question mark and not a period. So be as concise as you can be as focused as you can be, and we look forward to our discussion. The order in which we're going to present here was determined not by a random coin flip, but by amiable conversation. Starting off will be Daniel Tishner, the Philip H. Knight Professor of Social Science and Senior Faculty Fellow at the Wayne Morse Center for Law and Politics at the University of Oregon. Thanks. Okay.
Well, good morning, and actually I should probably say for a panel that's focused on ethical controversies that it might be unethical to make a guy on West Coast time start off this morning. On the other hand, I do have young children, so I think I'll be fine. So one of my charges, and one of the reasons that I think I'm going first, is to provide some historical perspective on our discussion. And as Mark Twain put it, history never repeats itself, but it often rhymes. So keep that in mind as we go along. My focus is the prerogative presidency, on executive power and its impact on the balance between security and liberty during perilous times. And I've been spending a lot of time these days either holed away in the archives or pouring through all kinds of documents associated with a variety of executives who served during the most perilous times. Lincoln in the Civil War, Woodrow Wilson in World War I, FDR and Truman during World War II, and the War on Terror. So I should start by reminding us that the Constitution is quite ambiguous regarding the nature and extent of executive power. Article 2, its vesting clauses are quite vague. In fact, I could have the entire discussion talk about this, but I'm not going to. But it's a wild card. There's a lot of elasticity to that article. And to capture this, Publius's split personality, I think, illustrates this well when Madison and Hamilton openly spar over Washington's power to declare neutrality several years later. Well, it won't surprise you to know that scholarship on executive power has been a growth industry since 9/11, and with much of it drawing inspiration from the aggressive, if not imperial, approach of the Bush years. And this literature draws lots of comparisons, all predictably unflattering of the Bush administration. let me get to the questions that I'm after. So the first of these is just a quote from John Locke about when I say a prerogative presidency, this is John Locke's definition of what prerogative is. Key phrase here is that a leader will act according to discretion, sometimes without the prescription of law, and this is really crucial, even against it. Then, I'm glad you quoted Abraham Lincoln. I think he puts these things so eloquently for us as a country in terms of this liberty-security balance. Here's a question you can return to throughout the day. Is there in all republics an inherent and fatal weakness? Must a government of necessity be too strong for the liberties of the people or too weak to maintain its own existence? And then this guy named Clinton Rossiter, a presidentialist from Cornell, 1948, writes a book with the provocative oxymoron of a title, Constitutional Dictatorship. And he says, he updates Lincoln's question, or he thinks he does. He says the modern version of this is that can a democracy fight a successful total war and still be a democracy when the war is over? I think he gets Lincoln a little wrong on this. He's right that Lincoln's wondering about what happens when the war is over, but Lincoln is also agonizing about what's happening during the war. That is, can we deal with executive excess and abuse? Can we have accountability during the conflict itself? Okay? So from this, I have three questions that I'm digging in my research. The first is, can we balance security and liberty during perilous times? The second is, what checks, if any, are there on executive power exercised in the name of national security? And then finally, do presidents exercise any self-restraint in their use of emergency powers? Well, I mentioned before that we had this growth industry of scholarship on the prerogative presidency since 9/11, and all of them cast Bush in unflattering terms in these comparisons. Let me give you three quick examples. I could take all day because there's zillions of these. But Benjamin Kleinerman, political philosopher, contrasts Lincoln in terms of understanding his use of emergency power as extra-legal and does so with great ambivalence. And he contrasts it with Bush, who exercises power as an inherent power within the Constitution and is hyper-aggressive. Scott Mathewson notes the obsession with expanding executive authority during the Bush years sets him apart from these earlier prerogative presidents. And Jack Goldsmith, someone who loves Lincoln and Roosevelt, and he contrasts Lincoln and Roosevelt with the Bush team, saying that in contrast to them, they were not executive power ideologues. FDR, he notes, and in quotes, used emergency power with discrimination and restraint. We are unlikely to think of President Bush this way. Well, I could keep going, but you get the idea. First off, let me say I don't follow the conclusion of Goldsmith and others in this regard. One punchline up front from my digging through documents and archives is that Lincoln was indeed quite anxious and circumspect in his exercise of this emergency power. But neither Wilson nor FDR, in my view, stood above Bush in showing restraint. Wilson was probably the worst. It's a long story I can't get into now. FDR, let me give you a quick illustration. By the way, here's our comparisons. This was a cartoon that appeared at the start of World War II, where people were wondering, is FDR a Lincoln? But I want to jump to Japanese internment, something that we know quite a lot about, so I don't think I need to rehearse too much of this for us. But let me simply pinpoint now that FDR, one of the key questions is, you could ask the Howard Baker question, what did he know and when did he know it? Okay? Because it's very easy to get anachronistic if you're not in that time. And one of the things that I heard from audiences who survived World War II was, you don't understand the fear of the moment when we indict FDR on internment. We all thought that there was a real credible fear on the West Coast. So you dig through the archives, and here's what you find. The top two top two intelligence advisors for FDR look into a number of allegations made by John DeWitt, who was the military commander on the West Coast, and at the time also the governor of California, Colbert Olson, and the attorney general, Earl Warren, were pushing hard for Japanese internment. So they're raising a number of charges, things like there's charges that, for instance, that in the cannery factories, Japanese were grinding glass and canned goods. or that gardens were being grown by Japanese in a way that it would point with the flowers in an arrow to where a particular munitions factory or airport is. So anyways, so there's like dozens of these sort of allegations. So FDR sends out his top 2 intelligence officers to look into this, and they come back and say, there's not a whit of evidence that backs this up. He then follows up by getting the top security guy from World War I to do the same thing, same result. J. Edgar Hoover from FBI, same result. By the way, how does DeWitt, who's the military commander on the West Coast, respond to this? He said, the very fact that no sabotage has taken place to date is a disturbing and confirming indication that such action will be taken. Okay? Well, what's interesting in this regard, and I have a quote here from Francis Biddle, who's his attorney general, is Biddle argues vociferously against Japanese curfew and removal, especially for Japanese American citizens. And he says, look, here's your intelligence. This does not make any sense. Well, FDR, and actually he has backing in this regard, and here I have on this slide from a document, confidential document from J. Edgar Hoover, no less, FBI, to FDR, basically saying, yeah, there's no evidence for this. If you want to improve the morale of West Coast folks, you can do this, but this is not going to be important for security. FDR goes ahead. So Roosevelt used emergency power with discrimination and restraint. I'll buy the discrimination part of that quote from Mr. Goldsmith, but I don't buy the rest. Well, one of the problems, I think, with existing accounts is that they are, historically unrooted. Why the difference between a Lincoln and a Bush? This literature's answer is that it comes down to character, the individual choices of those leaders. It's kind of great man theory. Well, character is important, but executive restraint and its reverse come from somewhere. There's a similar problem with the solutions offered to encourage executive accountability during perilous times in this literature, offered mostly, by the way, by political theorists and legal scholars who I think have been up front in writing about this. So liberal legalists say, look to the courts and Congress to promote some kind of accountability. Posner and Vermeulen would say, look to public opinion in elections. Extra-legal political philosophers would say, look for retrospective public judgment. Locke would like that. Let's take 2 of these really quickly. And the first is Congress. And I'll simply just say for now, because our fearless timekeeper is keeping me honest, is that in each of these cases, Congress is engaged in acting, but never in a way that's so much concerned about civil liberties. It's often delegating power for the president to be more vociferous in terms of constraining civil liberties. And I want to give you a quick example of this. Here's just some analysis I have from roll call voting. I think the first one's in the House, in terms of expanding executive power, especially military powers, during major conflicts. And the key thing to keep a look at is the percentages, is what percentage of those bodies affirm. And you'll see it's, especially in this era of polarization where you can't get people to agree on anything in the House, is that it's pretty large majorities. And likewise the same in the Senate. You may think it's the same thing, I just gave you a new slide. It's the same sort of pattern, okay? Well, what about public opinion? Well, I could say so much about this. I'm going to save it for when we're discussing this at some length. But for now, let me again just point to, let me again just point to a couple things. One, think of World War I. And I have here a cartoon from that period. And if you can't read it, you can see the cartoon, but here's a quote from Robert Putnam, political scientist at Harvard, who says, look, these war times are moments when we actually should feel like our social capital goes up, that we should revel in these periods because it's an opportunity for great unity and sacrifice. And indeed, we have wonderful examples of this. At the same time, though, we have lots of examples of that when the public is mobilized, we have a lot to be disquieted about. A great example from World War I is the American Protective Association, a group of kind of citizen vigilantes who were funded by the Justice Department, who were meant to enhance our security. And they engaged in surveillance of their neighbors, opened their mail, harassed them, and so forth. And that's a badge from the American Protective Association. So kind of pseudo-fascist stuff where they would wear that around, okay? By the way, in popular culture, we think freedom fries is new. Sauerkraut became Liberty cabbage, and hamburgers became Liberty sausage, okay, during this period. But let's fast forward to World War II. And here's just a really quick snapshot of public opinion during this. And most Americans support all sorts of constraints on our civil liberties during war. And by the way, it's a trend that has pretty much held up over time. Look at the last one on Japanese internment. And it doesn't go down much as the war progresses. And I'm going to give you one quick snapshot from a Gallup poll in 1942 in which folks said, what should be done with the Japanese American citizens who were already in camps? Said, what should be ultimately done with them? Assuming the war went on and on. And 56% said send them back to Japan, 14% said expulsion, kick them out of the country, and 8% actually affirmed some form of genocide, as one of the respondents said, kill them, get rid of them, destroy them. Okay? Public opinion is not something that I think is going to be a reliable solution. Well, let me just say, in closing, that a better way to get a handle on these questions, as I argue, is to keep in mind that context matters. The historical context matters. What happens when we root our analysis historically? Consider two developments over time, and this is really what I've been working on in my research. The first is the gathering of executive power. By this, I mean the rise of the modern presidency, the growth of the national security state, precedents for exercising emergency power. And in this regard, I'll show you a quick slide. This I found at the FDR library, and I'll keep talking since I'm on the clock, but you can read this, and then someone should nod to me, and I'll give you the second part of this when you've gotten there. But one of the things I want to talk about in this regard is to think about something that Rossiter notes in 48, that how long do these crises last? How do we know when they reach termination? The termination of a national security crisis must be followed by as complete a return as possible to the status quo ante, Rossiter writes. And we all know Jeffrey Stone's work in this regard about the pendulum swings back after these crises. But when does a crisis terminate? And does the pendulum really swing back, or does it really only go part of the way? Consider executive power and the so-called peace that follows several major crises. Along the way, rather than focus on the Lincoln-Bush comparison, consider a different set of pairings, prerogative presidents and the executives who follow them. So Lincoln and Andrew Johnson. Lincoln, by the way, his conception of executive power and so forth wasn't just rooted in his character, it had a lot to do with the fact that he was coming from a Whig tradition of a limited presidency. He's followed by Andrew Johnson when he exercises executive power. What happens to him? Impeachment. Fast forward Wilson, the peace of 1919, described by one author as a savage peace, vetoes efforts to rescind the Sedition Act during this period, the first Red Scare. By Harding, you do get a return to normalcy. Quickly, FDR and Truman. With Truman, we know the steel seizures case that suggests some limitation on the executive, and yet, in starting the Korean War, he violates both the Constitution and the law in 3 ways. Finally, Bush and Obama. So if it all comes down to character, is their character exactly the same? Because guess what? Their policies and civil liberties are awful, are basically the same. So on that note, I will just mention one other quick thing. Very, very quick, which is the second part of that, which is if that's disheartening about this expansion of executive power, I would point out that the other side of this is to think about the countervailing power. And another historical trajectory that's interesting to me is the growth of a civil liberties movement and human rights movement over time, along with a shift in our legal culture. We didn't know what civil liberties were, really, under Lincoln, and how that develops. And I'll give one quick example. One guy who was arrested in World War I for being a dissenter was a guy named Roger Baldwin, who first creates the National Civil Liberties Bureau in 1917, which then later becomes the ACLU. So on that note, I will cease and desist. Thank you. If you're interested, there's the other part of this. And I just would point out that when I was looking at this at the FDR library, so here's an argument by FDR about why, yes, I agree with the Constitution, but it's okay to engage in certain forms of surveillance. And when I was interested in who looked at this before me, and it was from the Bush administration, and the archivist confirmed that they had been a lot of interest in this document. So again, going back to the gathering.
The mention of Roger Baldwin is a nice transition to our second speaker. Hina Shamshi is the director of the ACLU National Security Program.
Good morning, everyone, and thank you so much to the McGuire Center and to the Tower Center for putting on this incredibly interesting event. There have already been a number of fascinating conversations that I've been delighted to take part in, and it's been a privilege both to take part in those conversations and to be here today. Let me start out with Daniel's pendulum idea, the idea of pendulum swinging back and forth in times of crisis. There was a much-cited lecture that the late Supreme Court Justice William Brennan Jr. gave at the end of the Cold War, and he reflected on the shabby treatment civil liberties have received in the United States during times of war and perceived threats to its national security. And Justice Brennan noted the cyclical nature of the nation's response to traumatic events. After each crisis abates, we remorsefully realize, he said, that the abrogation of civil liberties was unnecessary. And what Justice Brennan hoped for was that we might develop a jurisprudence of civil liberties that would be able to withstand what he called the crucible of danger and prevent this cycle from repeating itself. And we had, under Justice Brennan's formulation, this recognition that or the premise of his formulation is that our government was self-correcting over time. What is unique about the situation that faces us today, and this is one of three things that I want to address, is that although we no longer use officially under the Obama administration the nomenclature of a war on terrorism, we're still using the legal framework. And this is the question of, are we engaged in a worldwide war? How do we define our enemies? And when do we know whether or not this war will end? Because you see, the unique danger in trying to articulate a war against terrorism, or even a war against Al-Qaeda, which is a hard-to-define entity, is that the end of this kind of conflict is a very distant abstraction, not an actual event. In the past, we may not have known when prior wars would end, but we knew how they would end. And with now many of our political leaders, scholars, academics, claiming that we are in a war that takes place everywhere and that can last forever, I think that we have real concerns about whether Justice Brennan's equilibrium can be restored and whether or not we're in an always upward ratchet direction. Because you see, 10 years now have passed since the tragic events that launched this war. Al-Qaeda's leaders and many of his deputies are dead. Counterterrorism experts report that Al-Qaeda's capabilities have been crippled. And at a time when many think that our nation should be ratcheting down its war footing, there is a debate, one that I would posit to you is wholly contrived, about whether or not we should have a law enforcement response to the threat of terrorism or a war-based military response. And the way that these arguments are presented actually end up subverting some of our traditional values. Because while there is no question that terrorism is a global problem, I think we should be very wary of any policy that presumes that the entire world is a battlefield. If we don't want a world in which other countries have the license, for example, to assassinate their enemies within American borders, then we should be very careful about asserting the United States government has the legal authority to assassinate its enemies within the borders of other countries with which it is not at war and where it is not in war. But listen to some of the arguments about war as a law enforcement versus, terrorism as a war versus law enforcement paradigm. There are those who claim that Muslim terrorists represent an unprecedented threat to our way of life, that our existing laws, our courts, and our institutions, even our prisons, are not adequate to face this threat, that we have no choice except to dispense with some of our core principles, including even the prohibition against torturing people, to defeat this enemy. In short, according to this view, 9/11 changed everything, and we should all be hard-nosed, ready to be warrior mentality, people who respond to a whole new world. By contrast, those who are defending the vitality and viability of our constitutional system, who insist that our existing institutions are equal to the challenges posed by transnational terrorism, and who demand that we abide by core principles, including fair trials, humane treatment, and do not believe that we need to abandon our core principles are often derided as having a pre-9/11 weak and naive mentality. So we're in a discourse where adherence to Constitution values and those norms that both that generations of leaders have recognized were a source of our strength becomes a source of our weakness. But the danger here, apart from the always ratcheting paradigm, is related to that the underlying rationale has no definable limit. And the secondary danger is that in the last 10 years, our country has become an international legal outlier in invoking the right to use lethal force and indefinite detention against suspected terrorists who are far from any battle zone. And if we further entrench what we think of as the militarization of our necessary counterterrorism efforts, then our nation risks becoming a legal pariah to the detriment of those efforts. And so the dangers of a war-based approach to terrorism extend beyond specific policies such as targeted killing and detention. I fear that in the name of national security, our leaders are undermining our own long-term enduring security, which is the international legal framework that the United States helped to establish and that protects our long-term interests. No nation has a stronger interest than we do in the existence of clear rules on when nations are engaged in war and who can be held or killed in that war. And if the rules we apply are not clear, and they are not, they have not been, we compromise our ability to hold other countries to account. The second issue that I want to talk about is the extent to which our Congress, our courts, and we as public have internalized this emergency mentality. And that is reflected in the ways that these policies are playing out at home. I'll give you just one example. In the post-9/11 era, there was an understandable impetus to turn to preventing the next act of terrorism. But in applying that understandable impetus, we've gone a little bit too far. Some might say, I might say, quite too far. You see, one of the things that ended up happening post-9/11 is that even though, according to the 9/11 Commission, there was no indication that lack of surveillance as opposed to communication amongst intelligence agencies had been a problem that led to the attacks themselves, post-9/11, Congress granted extensive surveillance authority in the form of the Patriot Act. I'm not actually going to talk about the Patriot Act, but the executive branch also took upon itself the ability to grant authorities and to lift safeguards that had previously existed. So in 2002, 2008, the Department of Justice gave to the FBI the authority to engage in investigations based on no evidence of wrongdoing whatsoever, or a very low threshold of evidence that indicated wrongdoing might be occurring. The Justice Department also purported to ban the use of racial and ethnic profiling, but carved out an exception for the use of profiling in national security investigations and border integrity investigations. What was a loophole is now becoming an unconstitutional norm. The ACLU last year, very concerned about how these authorities in combination were being exercised, asked 34 of our affiliates around the country, asked FBI field offices to provide us documents in response to Freedom of Information Act requests to let us know what was being done. And what we have found is incredibly troubling. We found that the national security loophole was being used to target people, for example, of Arab descent, and Muslim Americans in Michigan, based solely on the assertion, according to these documents, that the State Department had designated terrorist groups from the Middle East and from Muslim countries, and therefore the FBI was going to map the entire community of Arab Americans in Michigan and Muslim Americans to identify sources of threats. This is not based on any instance of wrongdoing, it is based instead of the crudest kind of stereotyping. And we saw this pattern played out with African Americans in Georgia, with Chinese and Russian Americans in California, and with vast swaths of the Latino American communities in several states around the country. We are therefore, Joe started out by quoting the Constitution, the phrase at the very beginning of the preamble that talks about our more perfect union. And we are in danger of fracturing that perfect union with policies that single out communities for suspicion without any basis for believing that wrongdoing is occurring within those communities. These are also ineffective policies. For every law enforcement hour and dollar that is spent tracking down or trying to find leads based on mass suspicion as opposed to individual threats, those are wasted resources, and we end up also alienating communities whose cooperation is something that law enforcement requires and turns to. Let me take my last few minutes to focus on a third and final area, and that is the issue of accountability for torture. We now know that a far-reaching and sadistic torture program that was justified by unscrupulous government lawyers and authorized by the most senior government officials and carried out by military intelligence officials resulted in hundreds of people being tortured in US-run detention facilities at Guantanamo, at Abu Ghraib, at Bagram, and at the CIA's black sites, and that many prisoners died from that abuse. There is no policy or practice that has brought greater shame on America. But the stain of torture extends far beyond the damage to the nation's moral standing. The use of torture and our nation's failure to engage in any kind of formal legal reckoning with what occurred has degraded our rule of law. President Obama categorically disavowed torture when he came to office, and I would note that President Bush started putting an end to the torture policies in 2006, so this wasn't actually that much of a change from the end of the Bush administration. But President Obama's political calculation that the nation must look forward and not backward leaves the door open to future abuses. Apart from a few token prosecutions of the Abu Ghraib bad apples, virtually any individual with the involvement in the torture program has been able to deflect responsibility. The military intelligence officials who carried out the torture were simply following orders. The high government officials who authorized to torture were relying on the advice of lawyers. The lawyers were only lawyers and not policymakers. And so we've now got an impenetrable circle of impunity is what we fear, with everyone culpable but no one held accountable. And this state of affairs has resulted in the fact that not a single victim of the torture regime has yet had his day in court, and not a single court that was faced with a torture suit has addressed the core question of whether the victim's legal rights were violated. But without definitive adjudication of the legality of torture, we face the risk that our future leaders will turn once again to the dark side. Still today, the people who were the architects and enablers of the torture regime continue to extol its efficacy, and some have even claimed vindication with the contention that the intelligence leading to Osama bin Laden's safe house was derived in part from waterboarding sessions 8 years previously, an assertion that was very clearly refuted by intelligence experts and political leaders from both parties. We need criminal accountability to ensure that those who authorized and those who now defend the indefensible are never successful in reviving it. One of the ways in which torture has degraded the rule of law is also the fact that it is one of the principal reasons behind the astonishing fact that 10 years after 9/11, the alleged perpetrators of those attacks, although they have been in US custody for several years, have not been brought to justice. It is because those men were put into the torture regime, there is significant concern of what the prosecutions may reveal about the techniques and the extent to which those trials will become the source of reckoning. And that is a shame for all of us. That shows the ways in which torture, which is never justifiable under the law clearly prohibits it, metastasizes. It never achieves the aims that its justifiers purport that it will be able to achieve, and it harms the rule of law in ways that continue to do damage to our system, to transparency, and to accountability 10 years after 9/11. Thank you so much for your time.
And our final presentation on this panel before we begin the interactive discussion here is Robin Lovin, the Carrie M. McGuire Chair of Ethics at SMU.
Well, thank you, Joe, and thanks to the leadership of the McGuire Center and the Tower Center, both for the good planning that went into these conversations. I think it's always important before we plunge into the details of law and policy to take the time that we're taking at this first session to look at the broad questions. And it's most important to actually look at those background questions when the policy issues are really quite urgent, because that's how we get into these patterns that our previous speakers have talked about. You plunge in to take urgent action without thinking about the broadest background question. Ethicists are good at thinking about the broadest possible background questions. And so I want today to talk about the way that security concerns are reshaping the relationship between people and governments at the beginning of the 21st century. Security has been central to the relationship between people and government at least since the beginnings of the modern state. And anxiety about security is even more basic to human nature. We all know that we're vulnerable to the power of others, that events are not totally under our control. We all know that we must die at some moment, but we try not to make this be the moment. And as Thomas Hobbes observed a long time ago, that is the main reason why we're interested in government, that government is our ally and our instrument in this search for security. But as we have seen in the history that our previous speakers have talked about, as we've seen, it is also, government is inevitably our adversary in that search for security, and we're rightly concerned that government will exploit our anxiety in addition to, or perhaps instead, of providing security. But it's not only the people who are vulnerable in this adversarial relationship. Governments have anxieties too. And one of them is that the people will demand more security than government is able to provide. Since perfect security is precisely what an anxious people want, and at the same time an obvious impossibility, governments depend heavily on leading with a set of ideas that will unite people around the necessary risks of freedom. And that, I suggest, is exactly what our political leadership in an age of fragmented and polarized politics is failing to provide. We've learned to beware of leaders who offer us security at the price of freedom, but we're less alert to the problem I think we now face, and that is the problem of leaders who cannot motivate us to accept that freedom implies some limitations on security. But the future of freedom and security depends on knowing which set of risks we're facing at any given moment. For much of the 20th century, the main threat to freedom was the ideological state that used the desire for security as a tool to enhance its own power. Today, however, the demand to trade freedom for security often seems to come from the people themselves, though it's not always clear whose freedom they are willing to trade for their security. anxious about the future and uncertain about their neighbors, people today seem to be demanding of government more security than it is able or willing to provide. And in this environment, political leaders have their own anxieties. With a politics that is already polarized, no political leadership could maintain control of events after another major terrorist attack. And so governments of all political persuasions are increasingly reluctant to risk such an event. Legitimate security concerns about terrorist threats are magnified by anxiety about the political consequences of failure. In its strong form, this anxiety among the leadership is a genuine fear of anarchy. Without an idea to hold them together, the people may become ungovernable in a moment of crisis. And in a weaker and more familiar form, this anxiety is a fear that people will become ungovernable by us. That is, if they find us unresponsive to their demands for security, they will vote for somebody else next time. These anxieties are shared by those in power across the spectrum of politics. That's why governments of all parties look more and more alike. Once they are in power, this anxiety drives them all toward the same policies. So the old idea was that government will always be trying to increase its power by limiting civil liberties in the guise of providing security, and so we always know what we have to watch out for, governments that are overreaching and trying to limit liberties. In this new situation, however, the problem is not that government seeks too much power. The question seems to be whether government is able to give direction to the anxieties that are loose in the society at large. Without a sense of purpose, governments are vulnerable to whatever demands are put upon them by their people. We've become accustomed to ask whether governments are becoming too strong. The present state of politics suggests we may need instead to ask whether they are strong enough. There are three areas in particular that we should be concerned about when we ask that question. First, a government that is strong enough would be strong enough to limit itself to realistic, tested, and testable measures to provide security. The procedures it imposes would be directed toward known threats and based on strategies of proven effectiveness. Threats would not be ignored because they are difficult or expensive to monitor, and constraints would not be imposed just because they are easy to deploy. These goals are difficult to achieve when a new kind of threat suddenly makes an appearance, and some of the failures in this regard are in the immediate aftermath of 9/11 are understandable. But the war on terror, as we've remarked, has been in process now for a decade. And governments that are strong enough to give direction to the public concern for security should by now be able to initiate a public political discussion of security strategy, comparable to earlier discussions of military preparedness. Second, democratic governments must also protect all of their citizens equally. While every political order imposes some constraints on liberty in the course of providing security, the terrorist threat poses a particular risk that those burdens will not be evenly distributed. Immigrants, members of particular religious groups, and those who live by different values are easily targeted for scrutiny or for restrictions that others will be able to avoid. In a democratic state, government is responsible both for providing security and for protecting the rights of groups and individuals who might otherwise be singled out for discrimination. A government that is strong enough to do both of these things should also be able to do both of them at the same time. Finally, a government at war must look to the future, beyond present hostilities. A weak state will approach every conflict as though its survival were at stake. But a strong one knows that it will be around to establish relationships on a new basis when the peace is made. It's important to remember this lesson. from conventional diplomacy between nations, even in situations like this one, in which we now find ourselves, where the enemy is not easy to identify and the end of the conflict is difficult to envision. It is nonetheless important to build relationships, if not with the terrorists themselves, then at least with the groups and parts of the world from which they often come. A government that is strong enough to do that would be able to do it despite the pressure from an anxious people to treat the present conflict as a clash of civilizations in which only one side can survive. To ask whether government is strong enough to deal with this crisis of national security and civil liberties may sound like a dangerous question. Powerful states are always ready to manipulate anxiety and increase their power. And offering more power to that sort of state would clearly be a prelude to disaster for civil liberties. But weak government is dangerous too, because weak government is apt to lend whatever power it does have to reinforce the prejudices that its citizens have formed out of their own anxieties. That too is a prelude to disaster, and once again, the disaster is likely to fall most heavily on the weak and defenseless. To avoid the first kind of disaster, we must always be prepared to limit power. To avoid the second, we must also know when it is necessary to encourage leadership and vision. Thank you.
Thank you to our panelists for their comments. I, as an active chair, just want to toss out as the basis perhaps of getting a conversation going among the panelists, and then we'll turn to questions from our guests. After the Japanese attacked Pearl Harbor, we interred 110,000 American citizens. After the attack on the Twin Towers, the Pentagon, the crash in Pennsylvania, we interred no one. What does that tell us about America historically in terms of its treatment of attackers and its commitment to liberties?
Oh, I guess I'll get us rolling on that. There's a law professor at the University of North Carolina named Eric Mueller who I think addresses this pretty well. He's an expert on Japanese internment, and he ascribes the difference to a fundamental change in our legal culture and points to the fact that every member of the Supreme Court at the time that 9/11 occurred had at some point, either in opinions or in speeches, denounced the Korematsu decision. And so that's, you know, some good news. I also wonder to what extent, and actually Bush, from the very beginning, I think, made a very concerted effort to lead in terms of public opinion with regard to tolerance of those who are religious minorities and ethnic minorities. That is, in terms of Muslim Americans, he and Giuliani were very, very adamant about this is not something in which these groups are enemy. Contrast that with Woodrow Wilson, who targets the Germans and other immigrant groups. He says that basically this is disloyal blood within the arteries of American politics. He said we must confront them with the stern hand of oppression. Little wonder that we had, you know, mass publics then acting on that kind of lead. So I would point, I think Mueller's right in terms of a change in the legal culture, and I would also point to a certain form of leadership in this regard.
Joe, I think, you know, it's certainly true that we did not have that scale and tragic response to 9/11. And it's also true, as you were saying, that President Bush made some very notable and important gestures to prevent those kinds of abuses from occurring. Just a few days after 9/11, for example, he went to the Islamic Center in Washington, D.C., and said that the terrible acts of a few could not be ascribed essentially to the entire faith. But part of what we have to recognize is what did happen, although not on the same scale, which is that even as President Bush was speaking, the Attorney General was devising a program and implementing it in which South Asian, Arab American, and Muslim communities around the country were targeted for sweeps, detention, abusive interrogation, and large-scale deportation on minor immigration infractions in many cases. So there were, in fact, thousands of people affected, hundreds of people subjected to wrongful and often secret detention. And one of the things to come out of that, including out of reports from inspector generals within the government, Department of Justice, is not only that the fact that these abuses occurred, but there's not a single publicly known case of a terrorism prosecution occurring as a result of those vast sweeps and detention. But I think it's very important to note that the response was not at the scale of Japanese internment. At the same time, it's important to note that the damage that we have done in this context and the damage that was done amongst immigrant communities and people that, on the one hand, the government is saying, you're the targets for our suspicion, and on the other hand, the government is saying, we need your help. What's most likely to result in alienation, and how are we going to have long-term policies that unite us rather than divide us in a response to the threat of terrorism? And I think that that's one of the things that we have to keep in mind, the extent to which that mentality continues today in the ways in which law enforcement continue to target people, again, not on the same scale and not even on the same scale as we had at post 9/11, but the atmosphere of suspicion and the secrecy and the targeting for investigation, which is, as I was saying earlier, ineffective and counterproductive and does not enhance our security.
I would agree with what the other speakers have said, that the most obvious reason why nothing like the Japanese internment happened is that strategy had already been clearly discredited legally and in terms of its effectiveness. One can imagine a really disastrous scenario in which we forgot that 50 years of education from history, but fortunately our public response and our governmental response was more moderate than that. But it was also, peculiarly related to what we can now pull off in terms of the technology and the deployment of government resources to monitor whole communities. We have a kind of confidence that you don't need to inter people or disrupt their lives because you have such technological ability to keep track of what's going on. So in one sense, there's an exact parallel between the two situations. We used what we thought were the most effective tools available to us at the time without much regard to the rights and interests of the people who were targeted.
Just a quick addendum, great points, and I just wanted to also note that it's an interesting question whether Japanese internment was discredited writ large or what parts. And what stands out to me is that non-citizens are particularly vulnerable, even in the contemporary period in this regard. And
Korematsu has never been overturned as a matter of law. In fact, it's cited for strict scrutiny.
Could I actually just add one
Sure.
point to that, just in terms of the issue of singling out minorities when we're talking about national security threats? That the damage is done not just to the particular minority under scrutiny, but more broadly. People forget, but in the summer before the attacks, summer of 2001, after decades of hard work and advocacy by minority communities across America, Congress was considering passing the Ending Racial Profiling Act, which would have made racial profiling by law enforcement officials at all stages, local, state, as well as federal, illegal. That consensus broke down post 9/11 when Muslim, Arab Americans, South Asian Americans, and immigrants from that national origin became targeted. It's a broken down consensus still. We still do not have an Ending Racial Profiling Act. And so a set of policies that people believe might only impact a targeted group, that actually holds back the rest of America's minorities as well, because we are not outlawing profiling and unconstitutional singling people out for scrutiny in this manner for everyone because policymakers want to permit it for some people.
Let me just push this a little bit because I want to pick up on something that Robin said. That in some ways, because of technological changes and the like, we can accomplish the same sorts of things now as a government without interning somebody, simply by surveillance. In Korematsu, Justice Black, who wrote for the court, said that, of course, this imposes hardships on people, but war is an aggregation of hardships. One of the differences now, and if expanding this to something we discussed last night, something like airport security, more and more people are essentially sacrificing by going through security measures. So we're not targeting as tightly. The burden of the hardships has been broadened. Does that in some sense seem to lessen the civil liberties concerns, the violation of civil liberties?
The fact that we've
spread the burden in a way.
In the airport security context alone.
Right.
Right. Well, I think that...
We're using that as an example.
I think that there are still privacy issues that arise even in that context. But I think that's really not the context that we've been talking about here in many ways when we're talking about the use of technology or the singling out of communities, which is a problem, I think, that raises different concerns and has some different causes, right? One of the things that we talk about is identifying really what is the threat that you're trying to address, what is the source of the issue. And what we see happening is not fact-based threat assessments or not enough fact-based threat assessments, but the authority by federal law enforcement to target people based on suspicion that they might do something, not that they actually have done something or that they have taken steps towards doing something such that law enforcement has, at the very least, articulable facts that would justify investigation. And under the standards that exist today, without those articulable facts, there are very invasive techniques that are being used that actually don't rely so much on technology. Government is able to go conduct interviews with no basis for suspicion, but at workplaces, amongst family members, to conduct database searches about where people live, their addresses, social security numbers, who they live with, what their associations are, again, with no articulable basis for suspicion. And that, I think, is something that the majority may not see, but is very much something felt by and understood by minority groups that are being targeted, resulting in alienation that I very much am concerned will be to our long-term security detriment that we are doing this.
I have two reactions. And the first thought is about knowledge. That is, are people aware that they are sacrificing civil liberties? There's certain invasions of privacy in which you may have no idea. So why would you feel a sacrifice if you don't know? You might find out later, but so that's one issue to raise. The areas where airport security, we all have to take off our shoes and get out all those liquids and so on. We feel that burden, but there's lots of examples until we had the revelation about the warrantless kind of surveillance, kind of wiretapping stuff. We had no idea, right? The second issue is breadth, which is what I think has been emphasized in your question and in recent comments. And I'd kind of make an observation about public opinion over the time of a national security crisis, at least the data we look at from the 1940s and during the last decade. and that is at the front end, most Americans are fine, in fact, endorse the sacrifice, certain burdens that are for all folks. So take a data point like national ID cards. Like 90% of Americans favored it in the immediate aftermath of 9/11. As the decade progressed, fewer and fewer and fewer until it was a minority. So the willingness to absorb a general burden goes down. You know what didn't go down, and it goes precisely to your point, is targeted burdens that for particular groups perceived in a particular time as an enemy alien or particularly suspect or the other, not one of us, we've been very willing to sacrifice those civil liberties. And it stayed not exactly constant, but it has definitely stayed up at a higher level over the course of a crisis, and usually at a majority level, even as the immediate threat perception has waned.
And you see, I think, with the mosque controversy around Times Square, in terms of firing of the passions as well. With that, I'll open it up to questions from the guests. Herbert?
Yeah, maybe this should be directed at Daniel. Could you say anything about something that I read, that there was discussion about whether, for example, torture was done during the Second World War on Nazi prisoners of war? And my understanding is that we never did do that as a matter of policy.
Yeah, here's an interesting issue. So the answer is, can I say something about it? Well, yes and no. I mean, I don't have a lot of stuff that I've uncovered where I can tell you, yes, here would be your evidence on either side. So in that sense, no. But it does raise kind of a more general issue of how much is done during World War II that does not have scrutiny. So as an explicit policy coming out of the White House, I see nothing in that regard, or not much. Yeah, did you want to?
This is a question for Professor Tinchinar, and it will reflect my political bias, that there are some indications that in the previous administration there were deliberate attempts to increase the level of fear for political advantage. And my question is, how does that fit into your analysis?
Well, I mean, when you look at elections, well, we don't have a lot of long-term data, but in the 1940s, the war in both the war in 40 and 44, when people are asked, would you vote for FDR if you think the war was not going to take place or the war was over, most people said no. With the war, they said yes. Same kind of phenomenon in 2004. So threat perception definitely helps the incumbent. And it does kind of raise the question, which is a more general question about threat perception, which is just a general comment I would make, is how inaccurate we often are in the moment in perceiving just how great the threat is. An example I would give again is World War I. Where now, excuse me, we look back at it and we wonder, why were people so hot and bothered? But there was enormous paranoia about the enemy within, and that we faced real significant threats on these shores, which when we look back now, seem rather surprising. So I don't know if that goes after your question. Others might be able to address that as well.
I was actually going to address that question.
Yeah.
If
go ahead, circle back.
I don't know the history, although these discussions are fascinating. I don't know the history of what exactly happened with respect to Nazi torture. But the point that you were making, I think, is a very important one, which is that up until the actions of this previous administration, the use of torture, cruel, inhuman, and degrading treatment, which is the term of art under international law, had never been one of state policy. The aberration was what previously occurred when torture had previously occurred. It was condemned as an aberration, and it was prosecuted as such. We prosecuted people from the Korean and Vietnam wars for waterboarding our soldiers, the very kinds of things that were permitted now. And one of the things that I want to just point out is the post-9/11 dichotomous dialogue on torture, right? On the one hand, we had the Abu Ghraib torturers were bad apples. They were rogues. We do not torture. America does not torture. On the other hand, we had torture is necessary. in exceptional circumstances, which is why we needed the torture memos. And those two dialogues, discourses are utterly contradictory if you look at them, right? Either we torture as a matter of policy or there were bad apples. But instead we had the government saying both things at the same time. And that's this level of contradiction is one of the recourses of history's torturers in all regimes. You know, we don't do it, and yet we have to do it. And that's part of what I think we have to grapple with and understand now, looking back historically, at what our nation was going through and the justifications and what we need to do in order to prevent this from happening again because of the damage that it did not just to the victims, but to our rule of law and our long-term national security.
And I was going to say quickly, a related case would be the Kirin decision, the 8 German saboteurs who land on American soil, who there's some discussion that, and that's a really interesting story we can't get into, but that they had very rough treatment when they were seized. And moreover, when they're ultimately executed, at the time, the Justice Department and Francis Biddle said, we expect to give these guys, you know, based on the fact that they actually didn't commit the act, maybe 5 years, 6 years. And FDR wants none of it. He says, he basically tells Biddle, I don't want to hear about habeas corpus and so forth. We're going to do this by military tribunal. And it's a very summary process of execution for that.
And talk about the Supreme Court's treatment of it as well, because
yeah,
the decision came
so,
down.
So the Supreme Court is given the decision about whether, because the Milligan precedent would say, hey, you have civilian courts available, and some of these folks are are former naturalized citizens. You know, they have certain due process owed to them, and the Kirin ruling basically says, no, FDR may do as he will on this, that in fact the president can go forward with the military tribunals. And by the way, going back to preventive detention and so forth, when Ashcroft is being asked about these sorts of issues, you know, in the months after 9/11, I believe the case he cites over and over again is Kirin, which is basically saying a blank check for the executive.
Right now, it seems like we're analyzing what's going to happen in the future based on purely the sole action on 9/11, as disastrous as it was. And we've seen how other countries in the global community have reacted to consistent terrorist attacks. So how do you feel could be our nation's reaction if we, God forbid, do suffer another terrorist attack? Does that mean that we're going to have further infringement on our rights? Is our country going to say, okay, well, obviously we're not doing enough? Or, I mean, are we going to start thinking of a policy for terrorist attacks and not just in response to 9/11? Does that make sense?
Yeah, great question.
Well, let me go back to what I was saying earlier, which is we have to have a public discussion about this relationship between freedom and security, you know, because it's not just that you have to give up some liberties in order to have security, but that freedom itself, it requires some limitations on security. And it seems to me that one of the effects of this prolonged atmosphere of crisis, now running to a decade, I mean, you know, the Second World War had been over for 5 years, you know, by the time we reach this point in history. As that prolonged sense of crisis goes on, it delays having the public discussion about are these means that we're deploying effective, and are they really necessary? And so I think one of the things that has happened in other countries that have a more sustained experience of a lower level of terrorist violence is that they begin to see this, as some of the people have suggested, as a more ongoing police problem rather than an endless war.
I think it's a really great and difficult question, and if I just may, just how wonderful it has been to actually have engagement with the students over the last couple of days. This has been really fun. But one of the it is a deep concern that because this emergency mentality that has been internalized over 10 years has infected our courts, our Congress, as well as our political branch, that we will once again be repeating the mistakes of the very recent past, should, God forbid, the worst happen again. But that's why it's incumbent on all of us to examine what's happening now and to resist against efforts to entrench this emergency mentality, which is some of the things that policymakers in Congress are doing through legislation that is on the floor right now that would require military detention and prosecution of alleged terrorism suspects, and recognize how what should be cabined is not being cabined. Just as I talked about in the context of, people being profiled by the FBI for national security, now being profiled for ordinary law enforcement investigations. There are types of terrorism that occur in the United States on a pretty regular basis. A couple of years ago, if you remember the person who flew an airplane into the building protesting IRS policies, that's a form of terrorism if we're going to apply the same criteria. Are we going to say that we're going to deal with all of those threats in the same way? And if not, why not? And we've got to really be able to grapple based not on fear, but a genuine policy and considered response despite the fear-mongering.
Sure.
This question really follows up on both of the previous comments. We have the war on terror. We also have the war on drugs. It's been suggested recently that we might treat some of the drug cartels as terrorists. Our own governor has suggested sending troops into Mexico to help with the problem. This begins to muddy the waters conceptually between, as you say, law enforcement problems and national security problems. How do you deal with this? I mean, can you get rid of that rhetoric of war? Can you conceptually clear this up? And how do you go about it?
I was going to say, George Carlin has a great routine about war metaphors, war on everything. And you can add to how it muddies, because we also know that the recent conspiracy of Iran, targeting Saudi Arabia's ambassador involving drug cartel potentially right from Mexico.
I think it's just such a great problem. People were criticizing the war on drugs before the war on terrorism ever became an issue, right? And we've got to recognize what we mean when we talk about war. We use this term so easily. We're talking about the ability of the executive branch to unleash the coercive power of the state to kill and to detain without the traditional procedural protections we have in all other contexts. That's what we're talking about. And we need to be careful when we allow expansion of that power outside of what are traditionally understood as law of war contexts. I'm not saying we should never have law of war authority. Of course we should. The question is, how do you draw a responsible line between the two? And there is a difference between a battle in Kandahar and alleged terrorists in Kentucky, where in Kandahar we may need a military response, but in Kentucky our federal law enforcement and courts are perfectly capable of functioning. But the danger of this internalized emergency mentality that I keep talking about is just how expansive things are getting. The Austin, Texas Police Department wanted increase in budget for drones to conduct surveillance. There's discussion of drones being purchased for use over the Mexican border. I hear rumors of being able to use weaponized drones because transnational crime coming out of Mexico may be becoming such a threat. And we really need to make sure that we are cabining war authority to the appropriate context, because the reality is law enforcement has the sufficient tools that are needed to address the threat. It's not that it doesn't. We just need to make sure that the authorities are appropriately cabined.
Well, there's also a difference, I think, between using war as a metaphor to mobilize. So I'm thinking about FDR during, when the Great Depression breaks out, first inaugurally says, the American people want action, they want action now. And if Congress doesn't act, I will seize broad executive authority as if we were being invaded by a foreign foe. Fast forward, war on poverty with LBJ. So there's that component of it. But then there's also this other component of expanding the war powers themselves too, as you're saying, militarizing the border. In fact, Jim could talk a great deal about this.
It gets messier when you're talking about the national security of the Mexican state as a concern of the U.S.
The rhetoric puts you into hyperdrive governmental power. I mean, that's, Jeff?
We've been engaging in a pretty sophisticated discussion of policy and institutions, but I wonder if I could ask a question that brings us back to the individual level. The Kieran discussion, I had no quibble with at all. Everything that was said is correct, but the reason that we know about the Kieran decision at all is because a military lawyer who was assigned to represent the interests of those individuals defied the order of President Roosevelt and brought the case contrary to the wishes of the commander-in-chief. That suggests that there might be something about that individual's training, the situation of that individual in the context of a certain institutional environment that allowed that sort of, you couldn't call it whistleblowing, you wouldn't call it defiance, you'd call it an assertion of what he thought his duty was. So could you discuss in some way the existence or absence of institutional catalysts for individual action of that nature today as compared with yesterday?
I would just quickly mention that, when I first went in asking the question, what checks, if any, external checks on executive prerogative power existed, I thought I'd find the courts as kind of a line on this, and then you get to decisions like Milligan where the first line is, now that the peace is assured, ... The Korematsu decision. So, the 2006 decisions are a bit different, but Congress is not a reliable protection and so forth. I gave some examples of the public. What really stands out is that it's, political scientists would say we should fear the bureaucracy because it's that fourth branch of government that's unaccountable. And that's where we found one important source of limitation. That is, particularly in the Justice Department and JAG. I gave an example of Francis Biddle. You could go prior to that to Louis Post in the Justice Department during the Palmer raids, deportations. Fast forward to Comey in the Justice Department. So I think you're absolutely right that lawyers rooted in a particular institution with a certain sense of what their professional obligations are play a really critical role in this, as does, as I described, this kind of thickening of a civil liberties, human rights movement in the country. So even though the grim news is that there are very few checks on executives when the times are the most perilous, we do have some of these countervailing forces that have developed.
I think one of the most encouraging aspects of the past 10 years is that the opposition to the torture policies came from within the top levels of the military itself. The military lawyers were the ones who were fighting against executive branch lawyers who wanted to implement the torture memos, and the military recognized the damage that would be done to their own training of American troops, as well as the rules, the Geneva Conventions that protect Americans themselves from torture when they are captured by our enemies. I think what's disheartening about that part of it, though, is that while some of those people who were responsible for the torture programs have moved on to honors, Congressional Medal, Freedom, tenured positions and elsewhere, the people from within the military and within the CIA who opposed those policies have not received similar recognition. And this is one of the things that we've actually worked with other organizations to launch a campaign on, which we're calling Honoring Courage, where we've called upon President Obama to honor those men and women of the military services and the civilian agencies who stood up for the rule of law, for the military's training, and for values that they believed were enshrined in the Constitution in the ways that the United States works. But the other part of this is, and I think you raise a very important question about the individual level. There are, because institutions have internalized the policy, the emergency mentality, we are seeing situations in which the victims continue to be dehumanized. We are in court next Wednesday representing a man named Jose Padilla, who some of you may know. He's a U.S. citizen who was picked up in a U.S. jail, transferred to a U.S. military brig in Charleston, South Carolina, and subjected to some of the worst torture that you can imagine. He is incredibly damaged now as a result. And last year, a judge threw out our case on his behalf and on behalf of his mother. And one of the things that the judge found was the difficulty, he said, of litigating these issues in the national security context, and the concern that the judge had about hauling former top officials into court to give testimony about what they had done to this American citizen. My colleague Ben Weisner, who's arguing in the Fourth Circuit next week, I think put it best when he said that the court found that Jose Padilla was below the law and Donald Rumsfeld was above it.
Robin, go ahead.
Well, I just want to say the ethicists always like to throw in a word in favor of virtue when these questions are raised. You know, I mean, individual courage counts for a lot in those kinds of situations. But I'd also like to reinforce the notion that it's a sense of professional ethics that seems to be serving our purposes best at this point, both the sense of what, among lawyers, of what their obligations as members of the profession are, and you know, it really needs to be said that the military has one of the strongest codes of ethics in the area of these problems, and where you combine sufficient individual courage with appropriate professional formation, we actually get some very proactive responses.
Possibility of institutionalizing virtue?
Yeah. Yes.
But if I could just, to be a little bit contrarian on this, but I also think that we can overstate how much individual choice there is. And Obama's really interesting, right? He runs for office, I'm going to reinstate the rule of law, I'm going to close down Guantanamo Bay, and so on and so forth. And why doesn't he? And I would suggest one of the main reasons is a political one, a kind of a fear of what happens if something occurs on his watch, a backlash, a kind of a risk aversion that he has to be careful of. And when he tries, so anyways, I think there are constraints. You know, when he wants to try Khalid Sheikh Mohammed in civilian court, there's also a political backlash from his partisan opponents, but also by the American people. I also want to cheer individual courage in this, but also be aware that there's enormous constraints that certain figures face.
Question here.
Address this to Dr. Shamsi first, and the rest of the others can pitch in. In your first element, you listed 3 elements in your talk. The first dealt with our, call it assassination overseas of suspected threats to the country here. You made a beautiful case on that. But I'd like to ask you, are President of the United States and charged with the security of the country, and we're in what the favorite adjective now is asymmetrical world, in which our enemies are not from any country, they are individuals or small groups, and they all don't, none of them like us, and they are all admitted threats to us. Nobody denies that. Okay, you are President of the United States, and following the principles you outlined, and don't do what we're doing now, what is your prescriptive answer focused on the type practicality of the threat to the United States?
First of all, you've given me 2 honors that I do not possess. I don't have a doctorate, although I have a JD, and I am, much though I might wish to be not President of the United States, but...
The campaign begins.
If you'd like to start, you could be the campaign finance chair. You know, it is not the case that the rule of law, Constitution, and the legal framework prevent the President and our leaders from responding to threats. It is the case that there are limitations on the way that we respond that are based on decades-long experience and a commitment to the rule of law. So the President does have the authority, if we are talking outside of an armed conflict situation, to respond with the use of lethal force if the threat is specific and concrete and imminent. And that's an authority that has long existed and been recognized under both the Constitution as well as the international law that applies to these matters. And that's really what we're saying. It's one of the things that we sought in a lawsuit that we brought on behalf of the father of Anwar al-Awlaki. We recognized that the son was someone that most Americans would find distasteful is, I think, a gross understatement, but that the issue was not so much what he was accused of and may have done. The issue was about due process and the rule of law. And we wanted the court to be able to say that the circumstances in which the executive branch can exert its authority to kill, including especially when it is seeking to kill an American citizen, are limited to the ones that are recognized in law as being realistic, specific, concrete, and imminent. Now, the reality is that there is debate over what constitutes imminent, and I think that is a very difficult question on which we can have genuine discussion and disagreement, and what I may think of as imminent may be different from what you're thinking of as imminent, but that's not even where we are. We don't know the criteria that are being used, and the executive branch refuses to disclose both the legal standards as well as the evidence.
We've got 15 minutes, so try to tighten the questions and expedite the responses and get as many as you can. Ma'am?
I'll try to be brief. My question is both I want the historical perspective and the legal framework. One thing we haven't talked about is extraordinary rendition. And I like the historical perspective because it seems to be something that's rather new, but so far I've read enough intelligence books to know that really nothing's new. From going back to the Civil War, there was intelligence. So obviously there might have been rendition, but in what regard, since it was a domestic war. So I'd like the historical perspective, but I'd also like under what legal framework did the administration or have previous administrations justify extraordinary rendition? So one question, two perspectives.
So Joseph, you'll be really happy. I can expedite my answer to this. I don't know.
Next. Okay.
So, okay, very quickly, I would distinguish between two types of rendition. There's rendition to justice, where you're bringing people over to the United States or to other countries following a process in order for them to be prosecuted. And then there's extraordinary rendition, which is what we saw in the last decade, which is transfer to torture or transfer to be asked to situations where there was a likelihood that torture would be occurring. I don't think it's legally justified. There's no legal basis for it. And I do believe that the practice has largely stopped and largely stopped under the Bush administration. We've not seen evidence that it is continuing in the ways that it was. The ways that it sometimes may happen now very quickly is pursuant to diplomatic assurances that nations won't torture if we transfer people over to them. I don't believe diplomatic assurances work, and I'll leave it at that.
Prakash?
The panel has very rightly discussed civil liberties in the context of individual versus the state. But what about the non-state actors? The same emergency mentality is there in many non-state entities like business houses.
Mm-hmm.
What about the individual liberties there?
You've stumped us. That's a great question.
Just very briefly on this, I think one of the issues that the context in which this is arising is in the privacy and surveillance context, because corporations now have the ability to collect vast amounts of information from us, and there have been and continue to be ongoing efforts for corporations to share that information with the government, either through warrants and often not through warrants, which is what the warrantless surveillance sort of program we think might have been about. But I think that this is a new, not so new, but growing area of concern in which how is our information being gathered up and being used by private corporations in conjunction with the government. That I think is going to be another area for civil an area for civil liberties concerns and is going to be a growing concern area going forward.
And I would add to that with, in a different sense than focusing on business groups, which is, I talked about the American Protective Association as an example that had about 500,000 Americans and was, pretty well organized, and, all kinds of actions that, coming out of civil society that were directed towards, protecting security in the name of security, limiting civil liberties, or think about blacklisting during the McCarthy era. And so, I would suggest that signaling from political leaders can be quite important in this regard.
So it turns out you weren't stumped. I had a hunch.
Adriana?
It seems to me, and if I'm just wholly misrepresenting this, please do let me know, but it seems to me that the reason why a government can support something like investigations without evidence and racial profiling for national security is using, I guess, the rhetoric of prevention to prevent another attack. I presume that's what the government is saying. If that's the case, I see that as a viable end. I mean, that is sensible to want to prevent another attack, and that does seem within the role of the government. So is there a legal framework that you can imagine within which you can maintain that end but not violate civil liberties? How would that look legally or the policy?
I'm happy to address this, but I feel like I'm...
Well, again, ethicists are good at generalizations. That you can then tell me whether any of this makes sense in terms of the law. But I want to go back to something that I've said a couple of times. We have to think both about the way in which security limits civil liberties, but also the way in which having civil liberties limits security. These things work both ways. It would be easy to have a state, in which we would maybe feel some security against repetitions of something like the 9/11 attacks, but none of us would want to live in that kind of a state. So it seems to me that the answer to that question, with due respect to my colleagues, is not a legal one, but it's a question about the level of public discussion we're going to have and whether we will have enough information from the government to enable the public to make a judgment about the effectiveness of some of these strategies and the understanding of them and their effects over the long run. I have great confidence that an open public discussion would arrive at an equilibrium on these issues, that would be better than what we're blundering into as a result of non-transparent actions by both government and business, for example, as we were just saying.
Do you want to take a brief stab?
Yes, just very briefly. I think that I agree with you, but I think that there's also a legal component of this, which is that it's not an all or nothing proposition under the law either. Prevention is a legitimate goal, but we are able under our Constitution to have prevention without crossing constitutional lines. And one of the basic constitutional lines is that you've got to have some articulable basis to believe that wrongdoing has occurred. It cannot be that just because some members of criminal gangs are Chinese, that you can map the entire Chinese American community because they might become members of criminal gangs, just as it cannot be that because some terrorists are Muslim, you can go after the entire American Muslim community to map them.
Well, and just to add to that, it's not just that by doing that kind of mapping or profiling that you are basically placing the burdens on a particular group, but it's also bad policy for prevention purposes as well. Does it actually serve your ends, or do you end up getting confused in the process? And one thing I would just say from kind of a long temporal horizon, kind of historical perspective, in 2020 hindsight, how accurate are your perceptions of threat? I think that's something that can be, quite changeable over time, and we can get quite distorted perceptions of what threats are in the moment.
Okay, question back here.
Going back to the historical context, primarily, as we saw with your presentation, that when we saw FDR's, internment of the Japanese, even though he saw the evidence from J. Edgar and from other affiliates, he saw that there was no threat, and there was proof of that. But instead, he still went on with it because, as we saw with the public opinion. So going back to the context of 9/11, post 9/11, a lot of these decisions, it seems like during wartime, they are really stressed by what the public opinion is. And even though there may be contradicting evidence, that they feel like they have to pacify the public. And So how many, the question I guess would be, was how many of these decisions are actually based on real evidence, and how many of them are, they feel that they're coerced into it, and that if they don't do anything, that would look negatively on them?
I'm sorry, the last, I missed your last phrase. That
if they don't make an action, it would look negatively on them.
Well, and I don't know if you had time to read the slide from J. Edgar Hoover, but he basically says, Mr. President, if you're making this decision based on security reasons, it doesn't make much sense. But if you want to do it to improve the morale of the West Coast, go for it. So in that case, the answer would be that one is an example of making the decision based on opinion. The top security person, military intelligence person from World War I, who was also put on the job by FDR, said the whole idea of removal and internment of Japanese was the craziest damn idea he ever heard of. So, you know, but I think you'd want to go case after case to kind of carefully unpack it to see how often that happens, because I think we could probably find other examples where a chief executive would look at the hard evidence and say, no, I really do feel that it's in our security interest to do this. And then maybe the charge is then how well they balance that with civil liberties considerations. But I think the Japanese internment case, FDR was particularly, I think, how should I put it, crass or ill-headed in how he approached that. And I'd like to think other presidents aren't quite as flip in terms of how they handle that.
Yeah, we've gone back to the Civil War in this discussion and discussing civil liberties in terms of conflict and a constitutional perspective. But I was wondering if we can go back another 50 years to Madison, who wrote the Constitution, and discuss how he felt about civil liberties during conflict in light of the War of 1812.
And I don't want to, you guys want to jump in? No. No way. I mean, Madison is fascinating. I tried to hint at this at the beginning. You know, so the constitutional framing, what's the first branch of government under the Constitution? It's Congress. They spent a lot of time figuring out representation, figuring out slavery, figuring out Congress, and they were embarrassed about talking about the presidency, in part because George Washington was the guy who they thought would be there, and they didn't want to upset him in talking about it. But, you know, so Article 2, there's all kinds of debate. Richard Pius from Columbia, I think, has wonderful work on this whole initial area and what Madison's perspective on it. And initially, Madison basically favored much more of a weaker executive model. The Virginia Plan is a good example of this. And in this regard, he begins to move on the issue because he's worried about the executive having competent enough powers to check the other branches. So fast forward, he and Hamilton actually pretty much agree in certain respects about making sure the executive is competent, but they disagree about what the broad executive powers in Article 2 mean. I think it's safe to say that Madison is much more of a strict constructionist letter of the law, where the law is silent, the president ought not to be able to act. And Hamilton, having a very different perspective, that is spirit of the law, that the executive ought to have more free reign, especially in meeting various concerns to meet the public interest. So by 1812, I mean, Madison is quite circumspect in the way that I think Lincoln is in terms of exercising these powers. And I gave an example of, there was a big debate, Helvidius versus Pacificus, when George Washington issued his neutrality proclamation, where Madison, being egged on by Jefferson's always saying, take up your pen to defend my side. So Madison goes off and he challenges this use of power by Washington as beyond the pale. And so I think that's also reflected in 1812, where I think in many ways, Madison, if you want to go back even a few more years, Jefferson, when we're having this conflict with France, imposes an embargo on all trade relations and engages in all kinds of restrictions on business rights and civil liberties during that conflict. And Jefferson really contradicts many of his own philosophies in how he acts as a president at that moment in a way that I don't think Madison does. But I don't know if you have any particular perspectives on 1812 to... No, okay. That's my read, but you know, like most presidentialists, you can get another spin from somebody else.
We have time for one more question. Hiroki?
I have a generic question. So every panelist in the first panel talks about the trade between the civil freedom or civil liberty and national security. How much and how, if ever, Constitution and the definition of citizenship have helped solving that trade-off?
Yeah, repeat the very last part.
Oh, okay,
so
how
Constitution
has
and citizenship?
The definition, U.S. definition of the citizenship.
Ah.
In general, and there's some lie here with the Gitmo cases, but in general, in times of war, the courts have retreated from imposition of any kind of significant constraint on executive or congressional authority. We talked about Milligan, for example, but 2 years before Milligan, there was a case called Vallandigham, where someone who had been confined and tried by a military commission appealed to the Supreme Court, and the Supreme Court said in 1864, we don't have jurisdiction here. And in Milligan, in 1866, with the war over and with the acknowledgement that the war was over, all of a sudden civil liberties come back, and you always go into civil trial or civil courts if they are open. So these things, there are legalistic pushes and pulls, and I think the Gitmo cases might be part of this. In most instances, the courts have deferred to the elected branches.
I was just, on this theme, John Roach, who is a public law guy from Cornell and post-World War II, said, in emergency, it may be said that an emergency is not an emergency if the court is prepared to do something about it. But I would also add, on this, I don't know if this is part of what you're after, but there's a great book that I would recommend by a man named David Cole, a wonderful Georgetown law professor, called Enemy Aliens, which discusses what it means not to have citizenship during a national security crisis.
And with that, our first panel ends.